Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody, and welcome to our First Fridays for May 2025. While we're letting everybody join here this morning, and it looks like we have a number of really great questions already, over 40, I'd just like to do a couple introductions. So my name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. I'd like to personally welcome you to our firm's live virtual First Friday event for the month of May 2025. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also currently serve on my HOA board and have for many years. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live. Please do this as soon as possible, and then I will start answering all the questions between now and 10 a.m. Just a quick friendly reminder, due to the large volume of questions we receive each First Friday, this free opportunity is limited to one question per association. If you plan on submitting a question live during this session, please be sure to include the name of your HOA or condo and also your current role when you submit your question. Thank you for understanding. Okay, before we get into our questions today, and like I said earlier, we have over 40 this morning, so that's amazing. Let's talk a little bit about our legislature. So our legislature is in session right now, and it's been a busy legislative year. Over 20 bills were introduced pertaining to associations. And right now, as of yesterday at 8:45 p.m. when we last checked, there were 3 bills that have been signed by our governor now that are going to pertain to associations specifically. We are going to be sharing with you our pending legislation summary on Facebook Live and also on Zoom. So take a quick spin through that. As we get closer to the legislative session ending, we will be spending more time on our First Fridays and also on our neighborhood services, HOA and Condo Virtual Academy, talking in more depth about the bills. And of course, right before they go into effect, 90 days after the legislative session ends, we will be talking about them as well, just to make sure everybody's aware of what laws have been passed this year. Okay, so there's 3 bills right now that have been signed by the governor. I'm going to just very briefly touch on each one of those. The first one is Senate Bill 1039. This deals with meeting recordings of open meetings. And it says that this bill requires that if a board records a meeting that is open to members, the board has to keep a copy of the recording for at least 6 months and make the unedited recording available to any member, any homeowner who wants it on request of the homeowner. So if you're either audio taping or videotaping or recording on Zoom your board meetings as a board, you need to be, once this law goes into effect, which will be 90 days after the legislature closes, you'll need to keep that recording for 6 months, and any owner can request to see the unedited version of that recording. Okay, the next bill is House Bill 2322. This pertains only to condominiums, and it's going to be kind of a limited scope because it's commercial condominiums. But this bill addresses assessments on commercial versus residential structures in a condominium. And also included in this bill is a definition of commercial structure, common expenses, and residential structures. And again, this is only going to apply to condominiums that are of a commercial nature. The next bill is Senate Bill 1494, and this one is actually kind of serious. So the most important bill that we're going to talk about here today that has been signed by the governor is this bill. And this deals with foreclosure, and it basically amends, the Planned Communities Act, and it says that for the purposes of allowing foreclosure of an assessment lien, we can only foreclose once the delinquency is either 18 months delinquent or the dollar amount is $10,000. And so basically, this is a little bit different for planned communities than what we're used to. The old law said that we would have to wait either 1 year or be delinquent in $1,200 in assessments only. Now it's 18 months or $10,000 delinquent in assessments. And again, this only applies to planned communities. There's a couple other bills that have been moved to the governor. I'm not going to talk about those today because we don't know what the governor is going to do, but stay tuned. We'll be talking about that at our Neighborhood Services Virtual HOA and Condo Academy here the third Tuesday in May. Okay, let's talk a little bit about our questions for today. So it looks like we have 44 questions. As of right now, there might be some that trickle in as we proceed forward with the question and answer today, but let's get started. The first question is from an owner. Is it legally mandatory that monthly HOA resident invoices be sent hard copy by United States Postal Service in a forwarding not allowed manner? Well, there was a law that was passed several years ago that talks about the need for associations to send a invoice for any owner for their assessments. Now, some associations have had owners opt out of that and we're allowed to send it by email. So short answer would be yes, there is a law that says that. And yes, most associations are complying with that by sending the monthly or quarterly, depending on when your assessment is due for your association, a statement so that your owners know if they're delinquent or not. Okay, question number 2 from a board member. We had to condense this question a little bit because it was a little long. But the bottom line on this question is a unit owner's toilet flooded the unit below, and the HOA filed a claim on our condo insurance instead of the owner paying his $10,000 deductible to make a claim. Not all board members were notified. This was just a unilateral decision by our president. And now our insurance premium has increased by $10,000, which wasn't in our budget. Our manager says anyone can file a claim if common areas are damaged, but I thought only common elements were covered. Can we reverse this claim, and what should we do to prevent this from happening again? Really great question on insurance and very timely because we're getting a lot of questions from boards about how do we handle either our insurance being canceled or large increases in premiums right now. So these type of things are really important as we navigate insurance claims. So a couple of thoughts here. This was a toilet flooding. It's kind of unusual that it would flood the unit below. And so it does appear that there was common area damage if this is a condo. And it flowed from the top floor to the bottom floor. I have to look at your association's documents to see what the insurance requirements are. But generally speaking, it probably was correct here that the claim was made on the association since there appears to be some damage to the common elements. The two insurance companies, the owners and the association's insurance companies, will likely have to work out who's responsible for what. And if we have a deductible for the association's insurance policy, it'd be my opinion, I'd have to look at your documents, but that the homeowner would be responsible because the damage was caused due to the negligence or the negligence of the owner by not maintaining the toilet and having the toilet in their unit flood to the common areas and another owner's unit. So can you reverse this claim? No, once it's been made, it's done. And what should we do in the future? I think every claim that you make going forward, there should be an evaluation like, hey, is this an owner's claim or is this an association claim? Now if we reverse the facts on this one and the owner's toilet flooded the unit, their unit only, and didn't affect the common areas, didn't affect any other owner's unit in the association, in my opinion, that would have been a claim on the owner's insurance only, and the association's insurance would not have gotten involved. So best advice I can give you on insurance claims is just look at them on a case-by-case basis. Reach out to your trusted advisors, your insurance agent, your attorney, your manager to discuss, hey, is this an association claim or is this an owner claim based upon the facts? Okay, the next question is from a board member. What owner information must be kept in their office file? For example, like if we're 55 over community, do we need a verification? Do we need to have a warranty deed copy? Owner requests for architectural changes, proof they have copy of all association documents. Every management company or every association, if they're self-managed, is going to handle the owner lot files differently or the owner unit files differently. But typically what we see in an owner lot file, and we'll usually see it if there's like a problem, like the owner has a violation or maybe there's a lawsuit pertaining to the lawyer or to the association owner. What we typically will see in there is occasionally we'll see a deed, but that's kind of going by the wayside because you can get a deed so easily now from the Maricopa County Recorder's Office or the Assessor's Office through a link. We'll see any correspondence to the owner. We'll see like any violations that are specifically to that owner. Any communications from the owner to the association would typically be in there. Any architectural review requests, and then the response of the architectural committee or the board would be in there. Maybe there's evidence that they received the disclosure package, like you mentioned here, as part of the sale of their unit or lot. But it really just kind of depends. We have a great cheat sheet called Community Association Records and Documents in terms of what documents need to be retained and for how long. You may want to take a look at that. If you've got owner lot files, that are this thick, you may want to go through it and weed out the stuff that we don't need to keep. But as a general rule, I would keep the violations for sure. I would keep the architectural requests and the response by the association for sure. I would keep the age verification if you're 55 and plus community in there. I'd keep that current, plus any past residents that may have been living in there that provided that verification. Okay, next question is from a manager. According to your cheat sheet, how to work with rental properties. How it says that the HOA can charge a $25 fee for the change in each tenancy, but can the management company charge it since we're doing the work? How does that work? So we do have a great cheat sheet called How to Work with Rental Properties, and I would encourage you to take a look at it. We likely are going to be sharing that with you on Facebook and Facebook Live and on Zoom today. So basically, the fee does go to the association. It's a $25 fee for every change in tenancy, and that fee is capped at $25 based upon Arizona law. I think the way to manage it, so if the management company wants that fee because they're doing all the work for the processing of it, it really needs to be in the management contract that the association is responsible for that fee. So how it would work is the association charges the fee to the owner pays it, and then the association then reimburses or pays the management company for doing the work on that. But again, that would have to be negotiated and be part of the management contract for the management company to collect that fee. Or the association just agrees to give it to them, even though it's not in the management contract. Okay, next question, number 5, also from a manager. Wow, we've got a lot of questions today for managers. That's great. Our HOA condo association of 170 units built in the 80s and the 90s has been advised that our stairway railings no longer meet the current standards of OSHA and the international building codes. This could result in a future denial of insurance. What are our realistic options? This is such a good question. I've had this question previously from other high rises or low rise condominiums. A couple thoughts on it. It's expensive to replace these railings. And basically what it is, and actually for one of the boards that I'm a board member on, we have the same issue right now in our association too. So typically the old stairway railings that were built from the 1970s until like maybe 2010, the width of the bars on the stairways is wider. And now the code requires them to be narrower. And the reason why the code does is because maybe if a child was playing in there, they could get their head stuck in there. At least that's how our insurance company explained it to me when we had the same issue at our association. And so, yes, this is a concern. But it's also very expensive to, depending on how many railings you have to replace, it's very expensive to replace all the railings. A couple things that I've seen associations do, although it's not aesthetically pleasing at all, would be to add some sort of a device to make it meet the International Building Code. So whether it's like they solder in another piece of metal, if it's metal, or they wrap some sort of like a gauze, for lack of a better word, around the stairwell. So it's now totally enclosed. No one could even put anything through there, not even their hand. Or as part of a improvement project at the association, like if you're doing a renovation, that would be a good time to do it. It is scary that you got your insurance canceled because of it, although I've never seen that happen because of this issue. So from a realistic standpoint, you got to kind of weigh it. I think if you get a warning on it from the insurance company, it's something that you need to put on your to-do list. And if they say, hey, we're going to deny you if you don't do this, deny you coverage or increase your premium by a lot, then it obviously goes into the forefront. So I think good planning on this. Over time, you definitely want to change those out or do a modification so that it complies with the code. Okay, next question, number 6 from a board member. Our HOA membership legally voted to approve an assessment. The latter will not be invoiced until June after an approval from the city of Scottsdale. Some members, 18 out of 59, want to call for another vote to rescind the approved assessment. Can an approved assessment be rescinded or revoked? That's a really good question. I honestly don't think I've ever had that one before. Likely no. I don't. My feeling would be no. Once the special assessment is levied, then it does need to be, the board does need to enforce the collection of it, even though there's going to be a little time lapse here. And even like 18 out of 59, that's a small number of people. They can't go back and change their vote afterwards. They voted yes initially, and now they've changed their mind. Once the ballot is cast, it's cast. I think what I would do if I were in your board's position, this is a board member that's asking this question, is you need to pump out information about this project. Keep owners apprised about why there's going to be a delay until June, what the status of the approval is from the city, how this is going to benefit the community. And there's always going to be naysayers, but hopefully by pumping out good information, they're not going to turn any other people to change, their opinion on this. The one thing I worry about on something like this is that there might be like a recall petition of the board. And so having that good communication, maybe even having a town hall meeting, if this is becoming such a hot topic that people are upset about it, the board may want to have a town hall meeting to discuss it. I think that would be a good political move. But my opinion would be you can't rescind the assessment. It's been levied now. Obviously, the board could be removed, and then the new board says we're not going to collect it, but that's going to result probably in a lawsuit. Hope that helps you with that question. Okay, next question from a board member. In light of Tierra Rancho versus Ketchuvov, are board duties to the homeowners guided by ARS Title 10 or prescribed in the Restatement of Law Property Servitudes? So if we look at the case from 2000, the Tierra Rancho case, the Arizona Court of Appeals Division 1 holds that homeowners associations must act reasonably in their discretionary determinations, but homeowners bear the burden of proof that the association's acts were unreasonable. So it is kind of an interesting question that you're asking. When we're looking at, is the board living up to their fiduciary responsibilities, I would be looking, frankly, to Arizona Revised Statutes Title 10, which is going to be the Nonprofit Corporation Act. And there is a specific section in there that talks about fiduciary responsibilities. We really only look to the restatement law of property when there's a gap, when there's no answer. Like a good example of that would be if your CC&Rs have no amendment provision, meaning that it just doesn't mention that your CC&Rs can be amended, we may look to the restatement of law property servitudes for a gap filler as to what the percentage is to amend a CC&Rs if there is no actual amendment procedure that's in your CC&Rs. That wouldn't be in ARS Title 10 and the Nonprofit Corporation Act, the Condo Act, or the Planned Communities Act. But very rarely do we use the restatement of property. It's maybe like a once in 20 years thing that we do in our practice that I've seen. Okay, question number 8. We had to condense this question a little bit. It's from a board member. Our community manager is being harassed by a former board member who previously caused similar issues, even requiring a cease and desist letter from our attorney in the past. Now this former board member is making direct accusations against the manager and the management company. The manager wants to consult our HOA law firm, but we believe she should use her own company's attorney instead. While we don't support the former board member's actions, we're not sure this situation warrants legal escalation yet. What is the appropriate course of action here? Okay, so remember, you're a team. The board and the management company, you're a team. You work together. And if the manager is being harassed by a former board member who maybe used to be on the board and behaved in the exact same manner, and in the past, maybe there even was attorney involvement to deal with this board member's action, who's now a former board member, I do think that because you're a team, you need to seriously look at, is this actually something that is rising to the level of harassment? And Since we had attorney involvement before and it sounds like maybe it worked out then, you may want to consider having another letter sent. Think about the consequences for your board if you don't do anything. What do you think is going to happen? I can tell you what's going to happen. What's going to happen is the management company is going to quit because they don't want to deal with a homeowner that's former board member harassing their manager. Why? Because if the head of the management company doesn't address this, the manager is going to quit working for them. So this is definitely like a trickle down effect. And I think at a minimum, you should reach out to your association's legal counsel and talk about the issue, see what they suggest. And maybe the attorney should talk with the manager and find out more information about the harassment. It is not acceptable for an owner that's a former board member or owner that's never been on the board to be harassing board members, vendors of the association, such as the management company. And these type of things do need to be addressed or they continue to escalate and it gets worse. And it's going to ultimately end up in a situation where the management company will quit if you don't do anything. Okay, question number 9, also a condensed version. So this is from a board. I'm the board secretary for our association, and we have a contentious board and management company. I take the meeting minutes that include brief summaries of discussions following Robert's Rules of Order. However, our management company insists that minutes should only include action items, such as like votes, not discussion summaries. At the last meeting, the board voted to remove me as secretary and let the management company handle the minutes. Is that legal? Also, since recording of meetings isn't allowed, is there any way to keep a record of what happens in our meetings besides voting out board members? Okay, lots going on in this question. So a couple of things. You may not like my answer here, but I'm speaking the truth to you, and the practical aspect of this would be, so I do suggest that minutes really only reflect what was decided by the board and doesn't contain a lot of extraneous information. And you can look at our cheat sheet on community association board meetings, also our secrets on how to have a successful board meeting or an hour or less cheat sheet. We also have a cheat sheet on that. On the flip side of that cheat sheet, we talk about how to take perfectly proper legal meeting minutes. And I do state right in there that they should be as simple as possible. And it should really only reflect what was decided by the board at that meeting. I don't like having a bunch of extraneous information because it makes the minutes too long and a lot of the stuff is just fluff that doesn't really need to be included in there. So to answer your question about can the board remove you as secretary, I mean, I haven't seen your bylaws, but typically in bylaws, the board members can remove officers from their officer title. And so if your documents, your bylaws said that, they certainly have the right to do that. Do companies take the minutes for the association board meetings? Yes, that's pretty commonplace now. Or you hire a special minute taker to come in and take the minutes for the board meetings. You made a comment here that recording meetings isn't allowed. That's not accurate. Under Arizona law, the board can either record the board meeting, or an owner can record the board meeting if the association doesn't have any rules prohibiting that. And so certainly you'll have to check with your board. Are there any rules regarding recording meetings? If there aren't, then you certainly have the right to record the meetings, which might actually meet the needs that you want to have more detail and evidence in what happened at the meeting. Okay, let's talk about the next question, number 10, from a board member. Can a planned community let members serve hamburgers for a small donation at an HOA social event without any license? Ooh, that's a good one. That's kind of a tricky question because I don't know how many people are coming, and that's a tricky question. I get this question on potlucks a lot. I guess I'm familiar with your association. I know it's a large association. And I guess even like at my association, I think we had to go to the food handlers, a little online thing that all of us had to watch before we had a summer concert series where we were doing grilling hot dogs and hamburgers and had a free concert. It wasn't a big deal to get that food. I think it was called a food handler's permit. I mean, I think it took me like 45 minutes to watch the video and take a little quiz, and then I got mine. I think it would be best to comply with whatever the requirements may be in the county that you live in, or the city if there's any special requirements. I'm probably guessing it's going to be the county or state will have the requirements. You want to be really careful too that you're following the procedures to make sure that you wouldn't get anybody sick, things aren't properly refrigerated, etc. And if it's a big event, I think you definitely need to be doing that. If it's a small event, like let's say you're having an architectural committee meeting or something and you're going to have food there, I think that's overkill to go that detail and make them get their permit or the license that they may need. And the other option is you're a very large association. You might just want to bring in a vendor to help with these type of events so that the board can focus on building community and not have to worry about flipping hamburgers and keeping things at the right temperature. Okay, question number 11 from an owner. We had to condense this a little bit. 3 out of 5 board members met privately and approved spending $3,000. Other 2 board members or the community. The vote was never ratified in a public meeting, and many residents are unhappy with this spending. Can those 3 board members be required to pay the $3,000? Probably not. What I would suggest that you do is document at a board meeting, an open board meeting, what happened, and just make it clear that going forward, this shouldn't be happening again. You're welcome to replay this video for your board. People make mistakes, and I don't know if this was an intentional mistake or if this was something that was unintentional. They just got excited about something and moved on it quickly, and I don't know if it was an emergency too, because there might be an exception under the emergency provisions of the open meeting law. So it's hard for me as the attorney to only have some facts and not have the total 360 view after talking to the board too. So mistakes happen. If it was in fact a mistake, I think I documented in the minutes by talking about it at a meeting, have them ratify the decision after the fact, even though, maybe those 2 that weren't informed of it may be opposed to it. You still had a quorum and a majority of the quorum did agree to spend this money. It wasn't right. They need to do better going forward. And if these type of things continue to happen in the future, it's going to result in a lawsuit being filed against the association or having the matter, a case in the ADRE, the Arizona Department of Real Estate, where an owner sues the association or owner asks the ADRE to make a ruling that, hey, they didn't follow the open meeting law. And based upon what you're telling me, it sounds like they did. Okay, question number 12. We also had to condense this question. It's from an owner. Is there any law or rule that prevents a condo board candidate from transferring the votes they've received by mail, fax, email, or in person to another candidate after the vote counting has started or before the election meeting ends? No, there is no law on that, and that would not be allowed if I were helping with running the election. For example, a candidate withdraws after the ballots are mailed out, but before the election, can they give their votes, say 8 to 15 to someone else instead of letting them go to waste? No, they can't. Unfortunately, if that happens, those votes do go to waste. In the past elections, a large investor waits to see who's ahead and submits his ballots at the last minute to make sure he or his chosen candidates win. Is this allowed? Well, that really sounds improper because the ballots aren't counted until the meeting typically. And so you shouldn't be knowing how the vote is swaying one way or the other and then being able to make a choice based on that. That's improper. So I would say that should not be allowed. Okay, question number 13 from an owner. Our association has homeowner units, several offices, and a restaurant we lease out. My question, since office leasing is not in the governing documents, should office leases be treated the same as homeowners? Paying late fees. As a homeowner, am I allowed to request the office lease documents pursuant to the records request law? So lots of good questions going on here. I'm surprised that they're leasing offices if it's not in the governing documents. That is kind of unusual. So if they are leasing it, I'm assuming they're using like a written contract, a lease agreement with whoever they're leasing the space to. So should office leases be treated the same as homeowners with late fees? I mean, I guess that's typically a lease does have a late fee if you're not paying on time. Can I request the lease documents? Absolutely. It would be my opinion, you definitely can request those under the records request law. Okay, question number 14. Also, we had to condense this question. I'm kind of noticing a little trend here. More than like 25% of the questions here we've had to condense. So be sure when you're submitting your questions going forward that you keep them as simple and as straightforward as possible so that we Be sure to answer your question. I know that we spend a lot of time before First Fridays going through and condensing the questions. And as we get more and more questions, we have more and more success with this First Fridays, it'll be harder to do that. And we may have to throw out questions if they're just too long and we don't quite understand what's going on. So please make an effort, everybody that's listening, to condense your questions when you're submitting them going forward. Okay, this question is from a board. I'm the newest board member. After officer elections, 2 members declined all officer and committee positions, leaving us without a treasurer or a secretary. 3 days later, during a closed executive session, those 2 members who didn't want a role previously suddenly wanted those roles and requested a vote, which was held quickly. Now they claim they are treasurer and secretary. Is this process legal, and how should we proceed? Well, that vote really needed to be taken in an open board meeting. So I would recommend that you revisit this issue at an open board meeting and have the vote for the treasurer and the secretary in the open board meeting to reaffirm that decision. That's the best way to handle that. Okay, question number 15 is from a board member. How can I best address a majority of the board coming into meetings clearly having discussed topics without a quorum? For example, showing up to a meeting with proxy votes for topics that aren't even on the agenda. Okay, lots going on this question too, multiple issues. So less than a quorum of the board can discuss association topics outside of a board meeting. So if you have a 5-member board and 2 board members get together over coffee and talk about the renovations that are needed at the pool, that's okay, that's legal. But if you have a quorum of the board discussing association business outside of a board meeting, that is not legal. That's a violation of the open meeting law. Proxy voting is not allowed on a board ever. Proxy voting in elections and, for annual meetings is only allowed under developer control. Otherwise, you have to use mail-in or absentee ballots, but it's never allowed in the context of a board member being able to show up with a proxy to vote for topics on behalf of another board member. That's just illegal, and you can't do that. Okay, next question, number 16. Can meeting minutes from an annual meeting be approved at the next scheduled board meeting, or must the annual meeting minutes wait a calendar year to be approved at the next annual meeting? So annual meeting minutes it's the meeting of the members, right? The annual meeting of the members. And so you only have it once a year. So you do have to wait until the next annual meeting which is in a year typically, to approve the annual meeting minutes. Now, kind of a good practice pointer or tip would be it's okay for the board to review those proposed annual meeting minutes shortly thereafter the annual meeting, just to make sure that the content is correct. Now, they're not going to be approving it, but they're just doing a review of it while it's fresh in everybody's mind. I think that's a best practices thing to do, but you won't be voting on it. You'll just be looking at it, making any fine tuning or changes that might need to be made while it's still fresh in your memory. I mean, that's something you can do. I think that's best practices, but you're not required to do it. But bottom line is annual meeting minutes are approved at the next year annual meeting. You approved the previous year's annual meeting minutes. Okay, question number 17 from an owner. This is a condensed version too. The board, unchanged for 6 years, is unresponsive and hostile. The president openly claims control over unit repairs. On April 14th, I requested a list of board members, their roles and term lengths via email, but received no reply despite follow-ups. Other homeowners face the same problem. What steps can I take to legally compel the association to provide this basic information? A couple of thoughts. Go to a board meeting would be one thing that I would suggest. Hopefully they're noticing your board meetings and they're open board meetings, and introduce yourself to the board and ask for their names. If you request in writing the board members' names, they should be provided to you as well. You could also check with the Corporation Commission, the Arizona Corporation Commission, because if the association has filed the current annual report, the current board members' names will be listed there. So can you compel the association to provide you with the list of board members? I think yes, you can. Just make a records request. Their roles, you can ask for that, and their term lengths, you can ask for that. You may have to ask for meeting minutes to determine that on your own if they're unwilling to answer that question for you. But come on, if I'm advising a board and we get a request like this from an owner, I suggest obviously that the board would comply with this to give you the information that you're asking for. and not play a bunch of hide the ball games. Okay, number 18 from a board member. Our management company wants us to carry insurance for their employees. Is that a legal thing to do? And would the management company be named as an insured under the HOA policy? So I'm starting to see this more and more. In terms of insurance, the management company should have their own insurance, right? They should carry their own liability insurance. There should be their own fidelity bond. The association should also carry your own insurance and your own fidelity bond. Can the management company be listed as an additional insured on your insurance? Some management companies require that in their management contract. You probably want to check with your insurance agency to see if that can be handled. The bottom line is that if the management company has an employee that embezzles funds from your association, you want to have multiple streams of income coming in terms of the insurance premiums or claims that come in from claim money that comes out of a claim. But the management company should definitely have their own insurance for that as well. Okay, next question, number 19 from a board member. Our board is considering installing a few solar streetlights due to dark areas in the community. Could there be legal issues if the homeowner objects to a light being placed near their property? Also, if we don't install lighting and someone is injured due to poor visibility, could the HOA be held liable? So this is a good liability question. So if you are going to put in streetlights, you just want to make sure that A, you're putting them on common areas. B, you should check with your city, town, or municipality to make sure whatever you're doing is something that is approved. You may even have to get approval from them to do this, depending on if this is private property or maybe you're wanting to install it on property that is maybe the city's property, which probably won't be allowed. If you do install it on the association's property, I think that you should communicate with the owners why you're doing it. You should have lighting that points downward so that it's not shining into anybody's lot or unit, and talk to the owners about the need. If you do it properly and it's on the common areas and it's not shining into somebody's property, I really don't think an owner would have any objections to it. If they do, I think that we can overcome them. If we have to defend ourselves in a lawsuit. If we don't install lighting and someone trips and falls, yeah, that could definitely be a liability issue. If you're aware of a problem, which it sounds like you are, if you're thinking about installing lighting, and then you make a decision, no, we're not going to do it, and there's people complaining that they can't see, and then somebody falls, absolutely, that's going to be an insurance claim. And it's possible that you could be held liable, not you personally, but the board is going to have an insurance claim. You're going to be sued, and the insurance company for the association will need to defend you. Okay, next question, number 20. From a board member, what can the HOA do about excessive marijuana smoking in units affecting the units around them? This is a question that we get from time to time with smoking cigarettes and now with smoking marijuana, whether it's medical marijuana or, the legal amount in Arizona. Okay, so there typically is a nuisance provision in every set of CC&Rs. So what I would recommend that you do is review that section. I would reach out to the owner that is allegedly smoking in their unit and let them know we received a complaint about this. And I wouldn't make any allegations that it's marijuana. I would just say we've received a complaint regarding smoking in your unit and it's disturbing another unit owner, and open the dialogue with them as to what you might be able to do. Maybe that person can close up the vent, or maybe they can put some sort of a filter in, or maybe they can have some sort of an air purifier that's put in. These cases cannot be resolved truly by just a quick answer on a first Friday. Like, I've had these cases before. They are messy. They require communication and teamwork between the two owners, the one that's complaining and the one that's smoking. And they are often pretty difficult to resolve. The ones that we have been able to successfully resolve have been, we changed the venting system so that the smoke doesn't go through the vent. Air purifiers are put in. In some cases, the association pays for it just to make the problem go away. Air purifiers on both sides sometimes, one unit and the other unit, that's the complaining unit. But good communication, contacting the owner, knowing that you have the right as an association to contact the owner under the nuisance provision. These are all things that are tools that we've used to solve this problem in the past. Okay, next question is from an owner. What is the correct process for handling violations? I received a violation on February 13th and I filed an appeal. but never got a decision. Just saw a fine appear on my ledger on April 28th. After contacting the management company, I was told that my email appeal was denied, but I was never informed. Didn't I have 14 days to correct the issue after the denial? And how could I do that if I wasn't notified? So I agree it was improper that the board didn't notify you. So if you're getting a violation letter that includes a fine, let's say, we have to give notice of the violation, an opportunity for the owner to be heard, whether through a hearing or through writing a letter or an email to the board. And then we have to make a decision. And then we notify the owner of the decision. Now, I don't know if this situation is a fine situation or maybe there was just a violation letter sent, but it doesn't sound like the board totally followed the law on this. So I don't know what the violation is, but what I would recommend that you do is go to the board meeting, talk to the board. If you want to correct the violation, do that as quickly as possible and see if maybe they can waive whatever fines that they've been levied against you since you didn't receive the notice and you acted to get it corrected quickly. If I were the attorney for the association and we had a homeowner that came in and said that, I would say work with the homeowner and try to, if they corrected the violation, and they're sorry, let's all move on and waive the fine. Okay, next question, number 22. Can the post office come in and put cluster mailboxes in our senior community? Our HOA owns all streets and property. Regular mailboxes are much easier on our residents. So my office, I have a great team, by the way. Thank you very much to my team who helps prepare for these First Fridays and also our neighborhood services, HOA, virtual HOA and condo academies. So they already looked up this answer for me. And our office did a little bit of research, and the United States Postal Service does have the authority to determine the type and location of mailboxes for delivery. What you might want to do is contact that local post office to talk about your concerns and maybe some sort of a concession can be made here. Okay, next question, number 23. What is the name and number of the form to be filed with the county by June 15th and notify the street parking voting results? Okay, so we have a blog on this exact topic, which we're going to be sharing with you on Facebook Live and also on Zoom. And basically, it's actually not June 15th, it's June 30th. How it works is no later than June 30th. Well, first, this law only applies to certain categories of associations. So you have to be a planned community. The streets have to be dedicated to the public. And basically what the vote is that you're voting that you want the association to retain control over, the ability to cite for violations on the streets in the association, even though they're city-owned streets. You have to have a vote of your community no later than June 30th, 2025. And the question for the vote is going to be whether or not to continue to regulate the public roadways in your association. And if a quorum of the membership is met and a majority of the owners voting on that issue at that meeting vote to continue to regulate public roadways in your planned community, then you retain your right to regulate the roads in your planned community. The board then has to record in the office of the county recorder of the county in which the planned community is located a document confirming that the planned community continues to regulate the public roadways. And this issue is kind of becoming a very hot topic because we're already at May 1st. We have less than 60 days now to comply with this. And if you're an association that's a planned community and your roads are dedicated to the public and you want to continue regulating the roadways, you need to reach out to our office ASAP so we can talk about the process with you because we're now under a really serious deadline. And that recording, our opinion is that recording needs to be done by June 30th. I know the statute says that you have to call a meeting no later than that, but our firm's interpretation is that recording also should be done before July 1st, 2025. So lots to do if you're one of those associations. Reach out to our firm if you want more information. Make sure you check out the blog article because it gives a great summary of what the requirements are. Okay, next question is from an owner. Can you please clarify Senate Bill 1494 for assessments? It goes from 12 months to 18 months and $1,200 to $10,000. Is it either months versus dollars by what comes first, or is it just for condominiums? So really good question. Our reading of the law is that it only applies to planned communities, although I think we'll want to double check that since it's coming up now with the condominiums. Maybe my office can pop that law in at the end of the presentation and I can clarify that. Just cut and paste the full text of the law for me so we can make sure we clear that up. The bottom line is it is a either or. So once the new law goes into effect for associations, basically what happens is that you are going to have to, before an association can foreclose on an owner, the owner is either going to have to be 18 months delinquent in the payment of their assessments, or they have to owe $10,000. And that's a very high burden, right? It used to be $1,200 or 12 months. And so once that new law goes into effect, it's going to be more difficult to foreclose. I think probably what will happen is it's going to be the 18 months. It's going to be the default because getting to 10 grand, I can't think of one time in many years of practicing law that we have foreclosed on somebody that was over 10 grand that was owed in assessments, maybe a few times, but most of the time we're foreclosing for a couple $1,000s. And so that it's going to be either or. You're going to have to be one or the other. And actually, I'm just looking at the law. My firm is amazing. They've already copied it into the notes that I'm reading for these questions, and it only applies to planned communities. So condos, that will not apply. And actually, that's probably a lot better thing for condos because your assessments are higher. And I think it's a good thing that that doesn't apply to condos right now. Probably in the future it might be, but right now this bill only applies to planned communities. And again, it won't go into effect until 90 days after the legislature closes for this year. Okay, let's look at the next question, number 25. I'm just going to do a quick check to see we've got 47 questions. So we're moving in the right direction. This one is from a board member. And the question is, I'm aware of Arizona's open meeting law, the notification requirement, and that discussions among board members outside of notice board meetings is restricted to less than a quorum of the board. Much communication occurs via email. If an HOA establishes an open email system that allows all members of the HOA to view email correspondence between board members, and if the HOA makes the existence of such an email forum known and available to the homeowners with notice, would communication between board members between board meetings using such a system be in conformance with the open meeting law? This is a really good question. No, it wouldn't, but this would be a good thing to introduce to the legislature as a possible law. So right now, no, but I like your thinking. I think that would be great. I'm not sure they'll pass it because it's really been the intent of the legislature in Arizona to have all board business discussed at an open board meeting. Okay, next question, number 26, also from a board. We are a master association. We have only two sources of funding. One is through assessments charged against each of the sub-associations, and the other is to borrow money. According to our articles of incorporation, the association can borrow money and, with the assent of 2/3 of the members, mortgage, pledge, deed, entrust, or hypothecate any or all of its real or personal property as security for money borrowed or debts incurred. If a line of credit would be pursued instead of a traditional bank loan, would the 2/3 assent of the members still be a requirement to secure the line of credit? So good question from a board. So your master association, you need money. We only have two sources of funding, so we charge our sub-associations assessments or we can borrow money. My opinion is a line of credit is considered borrowing money, so you would need to get the 2/3 vote of the members. Okay, next question from a board member, number 27. Can an HOA planned community that has a true and appropriate charitable cause create a 501c3 charitable foundation through proper channels to serve the community within and beyond the HOA? I do get this question from time to time for different associations. I would suggest that you check with your CPA for your association. How I've typically seen this set up is that it's not set up through the HOA or condo. It's set up separately. And then, usually it's large master plan communities. Typically it's 55 and over communities that ask this question. And they want to do something charitable to give back. And I have seen this be successful, but I do think my understanding is go to your CPA to confirm that it's not part of the association and it's separate and it can be done. Okay, next question, number 28. This is from a director of a master association. And the question is, the deadline for our amended and restated CC&Rs was April 30th, 2025. With only 65% of members voting and requiring 55% approval to amend, Can the directors extend the deadline by motion? The governing documents do not address this situation. Okay, so we have a great cheat sheet on amending CC&Rs that might be helpful to you. Without seeing your documents, I'm not really sure what exactly you're amending. Maybe what you're doing is, okay, so I think maybe I understand. So you're trying to amend your CC&Rs. You gave a return date for the ballots of April 30th, 2025. You didn't get, you only had 65% of the members voting, and you needed 55 approval to amend. It sounds like you didn't get it. Can we push that out? The deadline, this is a good question. I would look at the amendment provision in your documents before I would give an opinion on that. It doesn't say you have to have a meeting to do it. And if you didn't get it by the meeting date, then maybe you can't. But if you don't have to have a meeting and it's just like a straight, balloting process, then probably you can amend it. It's a good practice pointer here is that whenever you're doing a ballot for a CC&R amendment, always put a sentence on there that says the board has the right to extend this ballot, the due date for this ballot. Just a good little thing a tip for the future. So it really depends on what your documents say to answer that question. Okay, question number 29 from an owner. The HOA's CC&Rs deem a payment late after 5 days. Management says ARS 33-1803 only applies when the documents of the HOA are silent and will not recognize item B. A payment is deemed late if it is 15 or more days after its due date. Can you clarify? I need to look up 33-1803 real quick to give you a good answer on that. Let's see here. 33 ERS. Probably should just move this. If I can't find it quickly, I'm going to move this to the backs because I want to give a good answer. But okay, let's see. My office is still good. They've got it on there. They know I have trouble seeing small things. So thank you very much. Okay. So your documents, your CC&Rs say late fees are due or are late after 5 days. Okay. So what the statute says is, let's see, a payment by a member is deemed late if it is unpaid 15 or more days after its due date, unless the community documents provide for a longer period. In this case, it's a shorter period. So the default is your association should be charging a late fee on the 16th day. So it's deemed late if it is unpaid 15 or more days after its due date. So I guess you could charge it on the 15th if you don't get the money in that day. Most associations would wait, just put it on the 16th. Your documents, the state law trumps your documents. So now let's give a different example. If your planned community and your CC&Rs say that its late fees can't be charged until it's 25 days late, then you look at this law and it says, okay, it's 15 or more days, it's a late fee, unless the community documents provide for a longer period. And so if it says 25, then you'd have to go by the 25. But in your case, we can't do that because yours is shorter. Thank you to my office for popping that up there so quickly. Okay, next question, number 30. And it looks like we have, We have 17 more questions. Okay, this is from a board member. If an HOA goes properly into executive session, can the board make decisions for the next steps on an executive session topic or vote while in an executive session on that proper topic? Or do they need to only discuss and seek information for the formal vote, come out of executive session, reconvene the public meeting, and make the motion to hold the vote? Public agencies permit an agency to instruct its attorneys in executive session, but states that legal action involving the final vote cannot be taken in executive session. I want to know if there's a similar requirement under HOA and condo law. Okay, so quickly, let's see. I don't know what topic you're discussing, so let's back it up a little bit. You can only go into executive session to talk about certain topics, right? And remember, if you're going into executive session, you still have to notice the meeting 48 hours in advance. You have to post an agenda, and you have to state which section under the law you're going into executive session for. My personal opinion on this and my legal opinion would be that you can take votes in executive session, and there's no requirement to push that out to the open session as long as you're talking about executive session topics. Now, there may be times where you want to notify the membership. So you may make a decision in executive session, like, for example, to settle a construction defect lawsuit. And maybe you want to notify the owners that the case has been resolved, or there's not a confidentiality provision, how much money the association obtained in the settlement. The board certainly has the right to do that in the open session if they choose. And so Hope that answers your question. There is no similar requirement in Planned Communities Act or the Condominium Act as you're talking about public agencies. Okay, next question, number 31, and this is from a board member. Is it required that an HOA CC&Rs and or bylaws be registered with the county? If not, what are the benefits of registering them? So yes, CC&Rs, which is also known as like the declaration or the declaration of covenants, conditions, and restrictions, slang CC&R, those are always going to be recorded with the county recorder's office. Bylaws, it's improper to record the bylaws. Those are just kept with the association's business records. The benefits of registering the CC&Rs is it makes them valid. That's the only way they're valid, is that they're recorded. There is no benefit to registering or recording the bylaws, and it's really improper to do so. Okay, next question from a board member. Our community has many outdated policies that need to be updated. What do you think of having a draft of the policy on our website for community review and allow written input and suggestions by members? Of course, the board will ultimately make that policy. So I'm not opposed to that. I see that you're a large master plan community and got a lot of policies, right? And you are thinking about asking for membership review and input on it. I think that's a great idea. What you might want to do is come up with the changes first and then send those out to the membership or put them on the bulletin board like you're suggesting so that they have an idea about what's being changed so you can stay really focused versus having somebody spend a bunch of time writing a bunch of stuff that the board would never consider. Okay, next question, number 33 from an owner. Our board resolved a temporary dues increase of $1,200 in order to mostly replenish our exhausted reserves. And this can be paid in a lump sum or in $200 payments over 6 months. Our community bylaws allow only for a 5% increase in assessments annually, which was already exercised, and our monthly payment raised to nearly $300 per month. Is this legal? This is hard because I don't know. I don't have all the facts. Like I don't have your CC&Rs, and I don't know if you took a vote in the membership to increase above the 5%. So this is a really hard question for me to answer. Is this legal or is it not legal? I would need to have the board contact me and give me all the facts before I could make a decision on that. Question number 34 from a board. Our HOA no longer paints the homes. What is the best practice to maintain a cohesive look? Guidelines to follow or rules to have an equitable standard for all homeowners? Okay, great question. Your association doesn't paint the homes. I'm not sure what you mean by no longer. Maybe that was an amendment to the CC&Rs or something that changed the policy. But a couple pointers for associations that the owners paint the homes. You may want to go to your national paint store that's in your neighborhood or near your neighborhood, like Don Edwards or whatever the one is that's close to you, maybe even Home Depot. And come up with a paint palette color for your association. I like going to a company like Don Edwards because they usually assign a designer to your association and for free. And they send the designer out to your community. They look at the surrounding areas and they look at what are the best colors. They also can give us advice about if there's any special city regulations regarding the reflective value of the paint, so that you make sure that you're putting on the paint color palette something that is not going to be a violation of city, town, or municipality's code. And so I like the idea because then they come back with, okay, these are the palette, and then the board makes a decision on the final paint colors. Typically, painting your home is a requirement that you have to get approval from your board or your architectural committee. So the board should publicize, here's our paint palette. And when you submit your application to repaint your home, you need to paint one of these colors. You need to indicate which color. And that's a good way to have a cohesive look. If you're looking in terms of the paint color, that they all are similar tones and that they complement, accentuate each other. Another thing that you can do if you're no longer painting the homes and now the owners are doing it is you can organize to have one company come in and paint all the homes at once, or as many homes that want to opt in at once. I've seen associations do that. It's more economical to do it that way too. Now, the association would not be coordinating that. We'd have to have maybe one or two of the homeowners be the lead on that. Okay, next question, number 35 from a board member. In 2024, House Bill 2325 added a few sections to the Arizona revised statutes limiting a county and or municipality's ability to regulate backyard fowl at a single family residence on a lot that is 1/2 acre or less in size. I can find nothing in the statute that grandfathers existing HOA restrictions preventing the keeping of domestic chickens on homeowner property within the HOA. Homeowners have reported recent sightings of domestic chickens within our community. Our HOA is exempt from complying with this statute if they have prior existing CC&R language. I'm pretty sure we have like a blog article on this if you check out our website. But the bottom line here is that associations can still regulate, if you have a provision in your CC&Rs regarding poultry or chickens, you still have the right to enforce that despite this law. I think that's kind of the bottom line. My office is so fast, they already popped this into here. And so mainly this was kind of like a municipality state issue with the fowl. Interestingly, chickens have always been an issue in associations. I can remember teaching classes back in like 1999 in the city of Glendale, and this was a very hot topic back then. But the association still can have its restrictions. We have a private contract with the owners, and we can still enforce those restrictions. Let's see. We'll move on to the next question. Number 36. This is from an owner who's a former board member. Can HOA boards require all owners to pay their monthly dues by forcing the owners to provide their checking account number for the HOA or the banking rep direct access monthly to their checking accounts? No, unless that's in the CC&Rs, I'm very confident that's probably not in the CC&Rs. No, boards cannot force owners to provide their checking account number and then, be able to go in and grab the money if the homeowner hasn't paid it. Question number 37 from a board member. Does Arizona law require HOA communities to have an independent audit annually? Independent is in quotes. Does it create liability for the HOA or board if it's not done? Yes, there is a statute, and it's been on the books for a long time, that requires associations to have an audit, review, or compilation done annually. This applies to planned communities and condominiums. The law is kind of loosey-goosey, though, because it really only says that you only have to have an audit by a CPA if your documents, typically the bylaws, have a provision in there requiring you to have an annual audit by a CPA. If your documents don't require that, it's kind of gray area as to who can do the audit, review, or compilation annually. And so a lot of associations requires an audit to be done by a CPA annually, the audit, review, or compilation to meet the requirements of the statute. And sometimes the third party is a board member, sometimes it's a management company, sometimes it's a financial group for the association, like a finance committee. It's loosey-goosey, and it's a flaw in the law, but I see why they did it, because why the legislature wrote it this way, because audits are expensive. We are looking at somewhere between $3,000 and $6,000 per year for an audit, and a lot of associations just don't have the funds to do that. So I think that's probably why that law was written that way. And does it create liability if it's not done? So first answer would be yes, they have to have an audit, review, or compilation annually. That's the law. Depending on who does it, depends on what your documents say. Is there liability if it's not done? Yes. I mean, there's going to be liability because there's a state law that says you have to do it. And if you're not having somebody who's competent, or you're not having somebody who's independent, and then there's, some embezzlement or some misappropriation of funds, yeah, you're going to get sued, and there's potentially going to be liability. Good thing is, hopefully you have a fidelity bond on your insurance policy, adequate fidelity bond on your insurance policy to cover any sort of fraud or embezzlement that might occur. Okay, next question, number 38, from a board member. Can the governing documents be changed to address member-to-member harassment that does not include any reason for law enforcement to be involved or for an order of protection? So good question. So I'm not quite sure what your spin on this is, but you can amend your governing documents, of course, as long as you get the vote of the membership to talk about this issue. It would be very unusual, though, because typically member-to-member disputes like Hatfield versus McCoy, those are typically between those two parties, and the association tries to stay as far away from that as possible. Really, the only time that we're kind of inserted in that is if there's a fair housing issue, like a violation of the Fair Housing Act, like maybe somebody's being harassed because they're a protected class under the Fair Housing Act, like maybe because of their race or their religious beliefs, or because they're families with children or something like that, that might be a protected class or handicapped under the Fair Housing Act. In those cases, if there's a Hatfield and McCoy situation and one party saying I'm being discriminated against by this other owner, the association would have an obligation to step in and act in that situation. But in most situations of the Hatfield and McCoy, we don't get involved, and we don't want to get involved because it doesn't directly relate to the association. Write a letter saying it's our understanding the dispute between these two neighbors, and we sent the same letter to both of them. If to resolve the dispute, you try to get mediation through the city. Most cities have a mediation program. If anybody's making threats to you, contact the police. Get your separate legal counsel and try to resolve the issues if you can't resolve them through legal counsel. But we generally kind of stay out of that. So I wouldn't be really in favor of putting something in there in the CC&Rs on member-to-member conflicts unless I had more information on how it would benefit the association. Okay, next question, number 39 from a owner, former board member. What is the expected norm for publishing HOA board meeting minutes, draft and final, for HOA members to access? Is it common to take a full year to make annual board meeting minutes available, either in draft or final version? So the expected norm, I would say, for regular board meeting minutes. So let's give an example. Let's say that we had our April board meeting. I'll give my association's example. Our April board meeting is always the last Wednesday of the month. So we just had it this week. And I would say the expectation is that at the last week of the month in May, we'll approve those board meeting minutes from the April board meeting. And then they can be distributed to the membership shortly thereafter, within a week or something, if that's your policy for your association, or maybe you just put them in the books and records of your association after they're approved. Or maybe you put them on the website. The more communication you can have with your owners, the better. So the faster you can process those and get those to the owners, the better. Should there be expected that those regular board meeting minutes are approved a week after the meeting? No, because we don't have a meeting until the next month and we need to approve the content of the meeting. Some associations put out draft meeting minutes in between, but most don't. Draft meeting minutes are not approved yet by the board. In terms of the annual meeting, yes, the reasonable expectation is you don't receive the annual meeting minutes approved until the year after, when you approve it at next year's annual meeting. Okay, next question, number 40. We are a cooperative. I see and hear things that I'm unsure is legal. I do not know where to go to find out if the things that are being done are legal. What are our options? Is there a cooperative version of the ADRE, which means like a state agency that will hear complaints between cooperatives? I'm not aware of any state entity that will hear disputes between a cooperative member and the cooperative board. It is a totally different beast, so to speak. Cooperatives, that they don't apply, the Condominium Act doesn't apply to you, the Planned Communities Act doesn't apply to you. It's basically just a written contract between the owners and the cooperative. I think actually it's not called owners, you're called tenants, or maybe sometimes you're referred to in a different, whatever the contract refers to the owners as. And so if you're unsure where to find out if things are legal or not, you're welcome to contact our office. We do have a handful of cooperatives in Arizona that we represent. I think there's only like 10 in the state, and I think maybe we have 6 or 7 of those. So I am very familiar with how they work and operate, and we'd be able to help you if you have a question. Okay, next question, number 41 from a board member. Not certain if this is a legal question. We have just gotten notice to our property management company. We've just given notice, meaning termination, to our property management company, and we just contracted with a new one. We would like to share the facts of our terrible experience with the prior management company with other people. Is there a public forum where we can do that safely? Thank you for any advice. So I guess here's one of those situations where the less you say, the better. I know that you had a bad experience with that management company, the prior one, and you want to tell the world about it. But if you put yourself out there and you start talking about this on social media, or you're doing bad reviews on Yelp or Google, you may be subjecting the association to liability for a defamation claim by that former management company. So I would recommend that you move forward and not go that route of trying to let everybody know what a bad manager or management company that prior management company was. Okay, next question from a board member. We are starting a beautification committee that will start out soft, and then eventually most likely will lead to enforcement of CC&Rs already on the books. Is there any way we can do this process through emails and written correspondence rather than have a person come to a board meeting? Takes up time, and we expect this to go to arbitration and be fought all the way to fines and litigation. These people are disruptive and obnoxious. However, we will follow state statutes in our administration to the letter. Okay, this question kind of like contradicts itself, because first you start out by saying, we want to have a beautification committee, right? Which is kind of nice and soft. It's going to start out soft. And maybe start talking to people about what are some things that you can do to improve your lot so that it looks better. But then you go right into, bam, we're going to go right into enforcement. And, we expect going to arbitration and litigation and fines. Here's the best advice I can give you. If you're behind on enforcing maybe some things that have been lax over the years, like maybe weeds, or maybe people's yards look bad because they're not picking them up or they're not maintaining them. The best thing that you can, this typically happens when a new board comes in. The best thing you can do is just start pumping out information about it. Hey, we're doing a community cleanup weekend and we're encouraging everybody to clean up your lots, because starting November 1st, 2025, we're going to be doing more enforcement if people's lots aren't looking nice. So give them plenty of time to do it. And then when you get to the enforcement stage, you probably want to talk with your attorney, like if the violation has existed for a long time, like you find a shed or something, we may not be able to enforce the no shed rule. But if it's a maintenance violation, you can enforce that even if there's been instances over the past 20 years where they haven't been mowing their lawn or weeding or whatever. You can still enforce that because those are, it's the existing violation right now, and it's not going to be grandfathered. Okay, next question, number 43 from a board member. We are looking into having a special assessment. Can we include an amount to increase our reserve account in addition to the repairs that are needed in our community? It really just depends on what your CC&Rs say about special assessments. What can they be levied for? What's the purpose of them? And if it's open-ended or general, you likely can do a special assessment to put money in your reserves. Now, I would really recommend that you reach out to our firm to discuss this, because you don't want to go through the whole special assessment process and then have someone legally challenge you and find out that you are doing a special assessment for something that you can't do. Okay, next question, number 44 from an owner. Getting down to our last few questions here. We have 4 more questions. Our HOA is under developer control. Homeowners are concerned that common area work, which is clearly developer liable, is being paid for from HOA money rather than out of the developer's pocket. The developer board raised monthly HOA fees such that there will likely not be a shortfall to be paid by the developer. Neither the developer board nor their hired property manager will work with us. What recourse do we have? So we have a great cheat sheet on this. It's called Transition from Developer to Homeowner Control that I think would be a good resource for you. You can find that on our website at mulcahylawfirm.com. You're in a difficult position when you're under developer control in your association because the homeowners are not in control of the board. And the developer is making all the decisions with regard to how things are being maintained and what the budget is and what expenses are being paid and by whom. What I would recommend is you certainly can make a records request and ask to see the financial statement for the association, the check register, and start looking at some of the things that the money's being spent on, or the association's money's being spent on. But as a homeowner, that's really all you can do until you get into a situation where the homeowner controlled board takes over. And that's going to be typically when the transition from developer to homeowner control occurs. If you think that they are doing something improper by making payments out of the association funds to pay for developer expenses, like paying for the trailer, for the sales trailer or something on the property, you should raise those issues in writing now. And when the homeowner control board gets into power and they're running the board, you may have a claim. The association may have a claim against the developer for doing that. And it sounds like maybe the developer's kind of savvy here. Like CC&Rs, it looks like, says that the developer makes up any deficiencies that aren't covered by the budget. And now the developers raise the assessments to a rate that there's really no shortfall. So, they're savvy and smart. The recourse you have now is request records, document your concerns, and wait for the homeowner control board to come into place to potentially make a legal claim against the developer if they acted inappropriately. Okay, next question. Our last three questions. Number 45 from an owner. When several board members are voting on a personal agenda against the best interests of a community, what are the best remedies for the membership? Our CCNRs are from the 1960s and are extremely vague. We currently only have 6 members as several resigned over this issue. So it sounds like maybe this is a voluntary association. If people can resign, most of the time you can never resign from an HOA or condo community. So it sounds like this is voluntary. I think probably you need to reach out to our firm to discuss this because I don't know if you're subject to the Planned Communities Act or the Condominium Act. If you think your board is acting inappropriately, of course you have remedies. You can remove the board. Under Arizona law, there's a procedure to remove the board. You can run for the board yourself. You can move. There's a lot of different opportunities. You can sue them. You can go to the ADRE to have an administrative law judge here. You can hire your own attorney to write a letter to them. There are a lot of different remedies that you can do. Okay, last 2 questions. This is from a committee chair. Patios are semi-common areas in our HOA. However, the walls of the building inside the patio are common property. We as a board intend to restrict what can be attached to those walls and how they can be attached. But this is a can of worms. What's beautiful to one resident is abhorrent to a neighbor. Any advice on how we can proceed to write a rule? Okay, so you've got like limited common element patios in your community, and the walls inside the patio are going to be common areas. And we're worried about people attaching things to the walls. This is a tricky question because some people like those iron suns and some people want, a planter that they can attach to the wall and then have flowers in the planter. I think you just have to decide if we're going to allow it, maybe write some parameters in terms of how large it can be, what materials, that if they damage it, the wall, that they have to fix it, or you just prohibit it altogether. It's up to your board. If you write something up, I'm happy to take a look at it and let you know what my thoughts are going forward. Okay, last question for today it doesn't say who, this is a board member or homeowner. A specific question on ARS 33-1818 regarding the vote on parking. Does this mandate that we spend the money to hold a vote? About $800, I'm told, from an attorney for ballot approval on the online voting company they use. Or we are in the city of Tempe and their rules on not parking RVs and boats is the same as what our HOA was enforcing anyways. So we don't really see the need to spend the money on a vote. But a property manager is saying that the bill says shall hold the vote, so it's mandatory. If it's mandatory, would it be just okay to send an email ballot to all? So I think maybe your management company is misusing mandatory on this. So if you want to continue to enforce it, whatever the restrictions are on the roads in your community, and this law applies to you, if you don't have this meeting to vote to continue being able to enforce the restrictions you have on the public roadways, you lose the right to enforce it. It doesn't say that it's mandatory for you to have the vote. It just says that understand the consequences. If you don't do it, the consequence is you will, lose the right to regulate the on the street, whatever the regulations are for RVs, cars, boats, trailers, campers, whatever. So it's up to you whether you want to do this vote or not do it. If the city of Tempe has rules on RVs and boats that can cover you on this, maybe you don't have the vote. And maybe you then just go to code enforcement with the city of Tempe anytime there's an issue with somebody violating the city code. But being able to enforce what's in your CCNRs, you won't be able to do that anymore on the public roadways unless you have this vote and meet the requirements of this vote. Okay, we're finishing right hour and 27 minutes, which is amazing. So we had 90 attendees today on Zoom. That is amazing. I think that might be one of our highest for First Fridays. We had 47 questions answered today, which is great. We got through a lot of questions in about an hour and 27 minutes. I want to give you a couple friendly reminders about a few other free opportunities, free learning opportunities for HOAs and condos, board members, managers, owners during the month of May. We have our HOA Condo Academy class, which is in conjunction with many neighborhood services departments throughout the Valley. We have our next class on Tuesday, May 20th, starting at 11 a.m. on Zoom and Facebook Live. We're going to be talking about board excellence. What are the roles and responsibilities of board members? How can you have an outstanding board? And what do you do if you have problems? You look to have a code of conduct. So we're going to be discussing everything that you need to know about serving on your board. And this really applies to everybody. It applies to board members because you should know what your responsibilities are. Managers should attend this so that you're keeping your board members accountable and on track with what their responsibilities are. And owners should attend too, because you'll want to know what the requirements are that your board should be following. We also have an in-person class this month, and that class, of course, is going to be on Zoom and Facebook Live. We also have an in-person class in Surprise on Wednesday, May 21st. This is an evening class from 6 to 8 p.m. It's going to be at Surprise City Hall. You can find out information on our website about all of these classes that I'm talking about. And the class for the City of Surprise HOA Summit is going to be on the top 10 things that get HOA boards in trouble and secrets to having a successful association. And those are two classes that we're going to be having, one virtual, one live in May 2025. Don't forget that our next live virtual First Friday event, similar to today, is going to take place on Friday, June 6th. And we hope you'll be able to join us for that class then. Thank you again for being here today and caring about your communities, wanting to make your HOAs and condominiums a better place. Have a great month of May, and we look forward to seeing you at one of our upcoming classes. Take care, everybody. Have a nice weekend.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.